Moore, chair of the Business and Finance Practice Group at a law firm called Silverman Thompson. And we're here today to discuss the Uniform Commercial Code as we are moving into the blockchain era. Unfortunately, I have to ask for slides to be advanced as we go along because we had a share screen issue. So, Catherine, we can go to the next slide. And this is a general outline of what we're going to cover. There are a number of changes in the UCC that occurred during the process between 2019 and 2022 when the new amendments were adopted. The amendments are designed to function smoothly, consistently, and predictably as technology advances. And so we can also advance to the next slide. Just confirm we're looking at the right one. Okay. The goal here with the amendments is to future-proof the free function of national markets and the flow of commerce. The Uniform Law Commission, which with the American Law Institute, they're referred to by those of us involved as the ULC and the ALI, appointed a study committee in 2019 with a broad charge to study the entire UCC. The committee identified a desire from market participants for more certainty in the law governing transfer of and financing secured by digital assets. The reason why we moved on to a drafting committee to create the amendments is that states were beginning to act on their own. They were enacting laws to make themselves appear more business friendly to cryptocurrency and blockchain businesses. The study committee recognized significant problems with this, including that these laws threaten to render the UCC, which is the Uniform Commercial Code, to render it non-uniform, either inadvertently or on purpose, and they created the possibility of choice of law problems. We can go to the next slide. The landscape at the time, if you look at the left panel and compare it to the right, the left panel is before 2022 and the right panel is after 2022. And before 2022 amendments, commerce under the UCC was built around paper and tangible assets. The world of finance changed dramatically as new forms of digital assets emerged, such as cryptocurrency, tokenized assets, smart contracts, and AI-generated records. The old rules did not anticipate the effect of technology on finance transactions. This resulted in uncertainty and non-uniform treatment by courts and market participants. This injured the value of assets pledged as collateral and increased the risk and cost of credit. Recognizing that markets flourish in predictable environments, the 2022 amendments to the UCC modernized the act by introducing technology-neutral rules that minimize legal uncertainty. New UCC Article 12 supplies the missing legal infrastructure for digital assets, which concern our discussion today. The foundational concept under the amendments to the UCC is control. Modernized secure lender is supported under the 22 amendments and encourages blockchain innovation. And we can move to the next slide. It should be pretty obvious why the amendments matter. Here we talk about very brief bullet point form why it's good why lenders want it, why blockchain companies want it, and why lawyers want it, or instead of want it, benefit from it. The next slide, please. The 22 amendments are rolling out nationwide, and I believe as of yesterday, although this slide may refer to 37, well, I don't know if it says 37 there, but 37 states had enacted the UCC as of the time the ULC posted this map of the nation to its website. You can see the URL down there at the bottom if you want to take a look at the resources directly on the ULC's website. So 37 states have enacted it, possibly 38 as of yesterday, and 4 states have introduced the 2022 UCC amendments, including Maryland, which is where I practice and am chair of the Uniform Law Commission in our delegation. There's a vigorous effort to achieve full uniformity. There's an enactment committee at the ULC which can provide subject matter testimony in favor of bills. And obviously, as you can see, with only a dozen or so states and jurisdictions left to go, it's been very successful. Why is uniformity important? Well, in the context of the UCC, uniformity enhances the free flow and growth of national commerce. That goal is achieved when parties to interstate finance transactions can rely on consistent rules and predictable outcomes, regardless of the states in which they operate. And we'll move on to the next screen. The centerpiece. So this is a new thing called a controllable electronic record, or a CER. It is exactly what it sounds like. It relies on the definition of three terms. It is electronic, meaning that a record is stored and can be retrieved in an electronic or other intangible form. It is a record, which is information stored in the retrievable form. It is controllable, meaning that a person can exercise substantially all the benefits of the CER, including the exclusive ability to prevent others from accessing it and the exclusive power to transfer control of the CER to a third party. Examples of potentials of things that could serve as CERs or assets in CERs would be cryptocurrency, such as Bitcoin or stablecoin, certain NFTs, electronic payment rights, and tokenized assets. And we can move forward to the next slide. The control is the logical evolution of possession, which is the old style way that one perfected a security interest in various forms of assets under the previous flavor of the UCC. Possession at the time was, with respect to cash, for example, the only way that you could get a security interest. You had to either have that cash in your possession as the secured party, or you had to have control of the cash under an agreement such as a deposit account control agreement, which those of us in the biz refer to as DACA. The new concept and mechanism of cryptographic control does the job with digital assets. Key innovations in Article 12 provide for control of CERs, which is, as we've just said, like possession of tangible assets, and it provides rules that allow good faith purchasers of these assets to take free of competing property claims. We'll talk later about the shelter principle, and it is an extremely powerful, stabilizing concept under Article 12. Why is all of this important? Under current UCC, cryptocurrency and other digital assets are classified as general intangibles. A security interest in a general intangible can be perfected only by filing filing first in time, filing a financing statement. First in time to file is first in right, and that governs priorities in general intangibles. However, this can lead to uncertainty with respect to perfection and priority in assets that are evidenced by a CER, a controllable electronic record, or interests in the CERs themselves. Under the amendments of Article 12, control becomes the equivalent of possession. Ready for the next slide. The next concept that's important to know is the qualifying purchaser. This implements the bona fide purchaser concept. A qualifying purchaser under Article 12 is defined as a purchaser of a CER or an interest in a CER who obtains control of it for value in good faith and without knowledge of any claim to a property right in that record. I should say a competing claim to a property right in that record. This definition is crucial for establishing rights in transactions involving digital assets. A qualifying purchaser acquires its rights in the controllable electronic record free of a claim of a property right in the controllable electronic record. This take-free rule applies only to the CER and not to any payment right or property right evidenced by the CER unless other law provides otherwise. There are exceptions. They are called controllable accounts and controllable payment intangibles that we'll discuss in a few minutes. Let's go to the next slide, please. So I'm sorry for the bad dad joke, but the shelter principle is important. It shields qualifying purchasers from undisclosed claims on the CER. The shelter principle applies even when earlier interests were only reflected by a filed financing statement. Financing statements now do not provide notice of a property interest in a or a property right in a CER. The problem with the financing statements is resolved by the concept of control that we just covered. A person with control primes the lien of any other party that only filed a financing statement. And the shelter principle in this way provides legal clarity by enhancing the ability to trade and transfer digital assets securely. And the principle is crucial for facilitating transactions involving digital assets as it promotes confidence among buyers and sellers in the marketplace. This is something that was being challenged under the old law. We can go to the next slide. Here we talk about the controllable payment intangibles and controllable accounts that I mentioned in the previous slide. A property interest in a controllable payment intangible is a remarkably flexible and powerful asset under UCC Article 12 when compared to a general intangible or transferable record under prior law. I don't want to read the slide to you because you guys all can read, so I will leave you to that. But we can move on to the next slide. And here's why I don't want to read slides. This one's dense. I know that, and I try not to flood slides with a lot of words, but there's really no better way to demonstrate the power of a controllable payment intangible compared to legacy intangibles. The highlights among these three categories, starting with the lowest flexibility of general intangibles, and moving then up to transferable records, and then now to the current concept of controllable payment intangibles. The controllable payment intangible leverages the maximum flexibility of a CER by streamlining what must be included in the record, the manner in which an interest in the asset is perfected or control, and the protection of qualified purchasers under the shelter principle. You can see in these three columns the requirements to satisfy each one of these assets. And it's, as you look at the three columns, quite obvious how much more flexible under revised or amended UCC Article 12 the controllable payment intangible is. We can move to the next slide. We've been talking mostly about security interests in assets contained within a CER. However, interests in the CERs themselves can be granted and realized upon. The amendments provide for this with new provisions governing accounts as collateral and account debtors. We will see how this comes into place with a number of evolving forms of commercial finance. Let's see, let's move on to the next slide. So here's how we get security interests in CERs. The financing statement is effective to perfect security interest in CERs themselves, whereas a financing statement is primed by a party with control of the assets evidenced by a CER. The difference here is that the CER, the financing statement, would be used by a secured party or a party acquiring a property interest of, for example, a portfolio of CERs. Move to the next slide. The choice of law issue came up during the drafting process and the analysis process, and there are three ways that choice of law can be determined with respect to an individual CER. The CER could the first choice under this is section 12107 of the UCC definitions. The first choice, if the CER itself chooses a jurisdiction, then the CER's jurisdiction will control. The next choice, if the CER doesn't select a jurisdiction, is if the CER is on a system, recorded on a system, for example, in an exchange. The exchange has in its own provisions a jurisdiction that it is chosen for UCC Article 12 purposes, then the exchange's rule will provide the conflict of laws answer. Finally, for situations where nobody's made an election about choice of law, the Washington, D.C. is the CER's choice of law jurisdiction. Keep in mind, as we discussed a few moments ago, that choice of law for CERs themselves under Article 9 are accomplished by filing, and existing Article 9 rules will apply under that scenario. We can go to the next slide. There are other changes that were recognized in the amendments to the UCC. One of them is electronic money. Article 12 excludes from the definition of money and an electronic record medium of exchange that is recorded in a system before the government adopted it as a currency. For example, Bitcoin. Now, there are some governments that have adopted electronic money. I believe the Bahamas is an example. And since that appears to be an emerging concept, and being aware that some countries are considering following suit, the drafting committee included provisions to govern issues with respect to electronic money. Approximately 1/3 so far of enacting states have deleted these rules because of concerns over a potential U.S. digital currency. The UCC, of course, is a state law. It takes no position on matters of federal law. And so the decision was made, we're not going to touch it here by those states. We can move to the next slide. Another change relates to chattel paper. This is, as you can see, a record that creates a monetary obligation secured by specific goods. Examples of that would be an auto loan or a lease or an installment plan for equipment. The revised definition provides flexibility here so that it comes under the provisions of UCC Article 12 and remains consistent and predictable. Other changes, another of the other changes is negotiable instruments, and the law clarifies that an instrument containing a choice of law or forum clause can still be negotiable, and the negotiable instruments provisions in the law conform to federal banking rules, allowing for deposit of checks by sending of a photograph. I think probably all of us are familiar with how that has been accomplished, and we rely on it day in, day out now to avoid going to wait in line at the bank. We can go to the next slide. Oh, I'm sorry. I forgot to say go to the next slide. We can go to the next slide. And here we have a discussion that states cannot cherry pick by adopting only Article 12. The 2022 amendments to the UCC were comprehensive, and they affected numerous provisions in different articles of the UCC. By just attempting to use Article 12, thinking that we're solving the digital assets issue by pulling that out of the other amendments, we will have a problem with non-uniformity and unpredictable outcomes. There are revised terms and definitions throughout the UCC that take into account electronic documents and electronic signatures. For example, a writing or a record, and there's a new definition of what is conspicuous under the UCC. There are new provisions in Articles 2 and 2A of the UCC that clarify when the UCC rules apply to hybrid transactions that involve both goods and services. Article 5 amendments clarify that a branch of a bank is still considered a separate bank for the purpose of determining governing law. Article 7 of the UCC has a definition of control that's been expanded to be consistent with the definition for control of chattel paper under the revision or the amendments. And new Article 9 also addresses the or provides new definitions for assignor and assignee. We can go to next the next slide. So what you might be wondering is there are some significant changes here. How do we slide this into place without disrupting everything? Well, we refer to those as the transition rules. And this is very important for loans against Article 12 assets. All security interests will remain enforceable, and there's something called an adjustment date, and the priorities among multiple creditors could change as we're making the transition into the control world of the 2022 amendments. So it's important for parties to make necessary adjustments before the adjustment date comes onto the calendar. An adjustment date will be determined by an enacting state's law. Most states have already, as you know, the 37 or 38 have already moved into the Brave New World, and they're in effect. But it is important to maintain uniformity, and if you've got a transaction that's governed by a law that has not been updated to the 2022 amendments, there could be unpredictability, instability, more expensive credit, and it would restrict the ability of companies in those jurisdictions to compete with companies that live in jurisdictions where the modern rules are located. Let me see, make sure that we were talking about, yes. So we go back to, yep, all right. We can go to the next slide. We're way ahead of schedule here. Perhaps I went too fast, but our takeaways. The concept of the amendments to the UCC is a motivating consideration for most lawmakers deciding whether to support enactment. For those who recognize the value of the modern law, it's really a no-brainer. And that's why we've seen in just, 4 years, 37, 38 enactments and well on the way to uniformity. Everybody recognizes the value to their state. For the remaining dozen or so states that have not yet updated the UCC, they have to get on the train or it's going to leave the station without them. Uh, the the same principles here apply as we discussed at the very beginning as the reasons for why the UCC is being updated. And so if you have any access, if you are in a state that has not yet enacted the 2022 amendments to the UCC, which I do, Maryland hasn't done it yet. It's tried twice, but was non-uniform each attempt. I believe next year we'll get it done. I urge you to contact your legislators, find a sponsor in both your House and Senate, share the information that is included in the materials for this presentation, and encourage them to consider that and to reach out to the ULC. There's a gentleman named Ben Orzeski, Orzeske. His name will appear in the materials for this program. Ben's job is to work nationwide with every state that is involved in an enactment process. So it's something that I think that the ULC can provide a lot of support for, or I know that the ULC can provide a lot of support for things such as providing written testimony to the legislators, to the committees, or live testimony or virtual testimony like we're doing today. In fact, the reason we're doing this virtual testimony is that I'm at the annual meeting of the Uniform Law Commission, presently being held in Chicago, where the ULC is headquartered. Otherwise, I would have been there live with you all in person. The next slide is the lawyer print. Obviously, what we're talking about here is educational, not legal advice. And we can go to the next slide, which is our conclusion. The amendments to the UCC are numerous and very detailed and really of more interest to at that level to lawyers. But for those of us who are part of the blockchain economy, the blockchain world, I think that what we have here is a really good overview of how it's being provided for in the law. And I appreciate your time this morning. Catherine, would you like to wrap it up, or Jackie?
Yeah, if anyone on Jackie's side has any questions that they would like to ask, I'm not sure if they, oh,
No. No, we don't have any questions on our end, but thank you so much for your time and your presentation.
Of course. Thanks for the opportunity to do this, and have a great day.
perfect. Thank you, Steve.
Thank
Mhm.
you too.
Bye-bye.